for the state. So any law that is made in future can be applied by the president under 371B. Then note, such other matters in the state list as with concurrence of government of state resident may by order specify. So what this is futuristic exercise of power by the president from time to time. Likewise, Lord, in D, such other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modification as president may by order specify. So power of president is not a surviving power to be exercised from time to time. That is why the words notwithstanding anything contained in the constitution are important in the opening of the article. Now just turn to Mr. Iyengar's broad statement. Please turn to PDF volume.
Away.
Why not?
Whether under the second proviso,
Yes.
to D, all the provisions of the constitution could not have been made applicable with the concurrence of the government.
Yes.
So is it not possible that if there is a concurrence of the government under D, the entire provisions of the constitution could be made applicable to Jammu and Kashmir?
There could have been, except 370 can't be.
Except 370.
Yes, 373 is something which is left to the will of the people. There is no difficulty. Government says
then what remains if everything under the constitution can be made applicable by exercising the powers under D?
No, it needs consultation and concurrence.
That's what if
Yes.
with the concurrence of
Yes.
the question that is being
No
put is
difficulty, it can be, undoubtedly. But the power of removing Article 370 is disappeared.
a different power.
That's an independent power. And government union in its affidavit has stated that all provisions of articles of the constitution have been made applicable to Jammu and Kashmir. And they have said that there is no difficulty on that. It has worked very well. They say so. There is no doubt that 370 has worked beautifully since 1947. This relationship. There has been no difficulty. It's not Government of India's case that there were impediments in running the administration of the state for any reason. Except national security and some violence, they have not given any other reason also. So this has worked, it must continue to work. Now why it should continue to work, please see Professor Dr. Iyengar's broad statement. PDF volume 8, page 1175. The words again, the government of India had committed. 5 minutes. Your lordships have got it.
Again, the government of India.
Yes. Again, the government, my lord Justice Call has got.
Just one.
Telling the learned law clerk that they are so lucky that they get opportunity to work with your lordships. When we started practice, each one of us, we didn't have that facility. We all learned on our own.
We are equally fortunate to have their assistance. They are very talented.
The quality of assistance they give, especially matters of this nature,
Yes.
it's a Herculean task just to marshal the records, and they assisted tremendously in this.
No, in fact, I had to work hard to get my intern in court today. I wrote a very personal letter to the assistant registrar and said, please, for God's sake, allow them to come in. Because their assistance is amazing and their experience, the memories they carry back home are unbelievable. This generation of students are outstanding, these lawyers. They are far more better than my generation was. Again, the government of India have committed themselves to the people of Kashmir on certain respects. They have committed themselves to the position that an opportunity would be given to the people of the state to decide for themselves whether they will remain with Republic or wish to go out of it. We also committed to ascertaining this will of the people by means of a plebiscite, provided peaceful and normal conditions were restored and impartiality of plebiscite would be guaranteed. We have also agreed that will of the people through instrument of Constituent Assembly will determine the constitution of the state as well as sphere of union jurisdiction over the state. Now, kindly turn over and please come to Lord page, the last clause, 8 pages later. The last clause refers to what? In fact, right from top, then we come to clause 1178. Then we come to clause 2.
Mr. Dave, the portion you have read is part of the Constitutional Assembly debates relating to the Indian Constitution.
Yes. Part of the Constituent Assembly debate on 17th of October 1949.
Correct.
Now, my lord, 1178, my lords may turn to.
1178.
78. Then we come to clause 2. You will remember, then we come to clause 2. You will remember that several of these clauses provide for the concurrence of government of Jammu and Kashmir state. Now these relate particularly to matters which are not mentioned in instrument of accession. And it is one of our commitments to people of government of Kashmir that no such additions would be made except with the consent of the Constituent Assembly, which may be called in the state for the purpose of framing its constitution. In other words, what we are committed to is that these additions are matters for determination of Constituent Assembly of the state. Then about one paragraph later, the last clause refers to what may happen later on. Now see this, Lord. We have said Article 211A, which is 238, will not apply to J&K. But that cannot be a permanent feature of the constitution of the state, and hope it will not be so. So the provision is made that when the Constituent Assembly of the state has met and taken its decision both on constitution for the state and on the range of federal jurisdiction over the state, President may, on recommendation of the Constituent Assembly, issue an order that this Article 306A, which is 370, shall either cease to be operative or shall be operative only subject to such exceptions and modifications as may be specified by him. But before he issues any order of that kind, recommendation of Constituent Assembly will be a condition precedent. That explains the whole of this article. Now see next paragraph. The effect of this article is that the Jammu and Kashmir state, which is now a part of India, will continue to be a part of India. But the bogey is today in the country a wrong narrative that Jammu and Kashmir is not part of India because of 370. That's not so. As Jawaharlal Nehru also refuted when K.M. Shah said that yes, plebiscite. He said nothing doing. It's part and parcel of India. It's integral part of India. Unit of federal and the union legislature will get jurisdiction to enact laws on matters specified either in instrument of accession or by later addition with concurrence of government of state. And steps have to be taken for purpose of convening a Constituent Assembly in due course, which will go into matters I have referred. When it has come to a decision on the matters, it will make a recommendation to President who will either abrogate 3068 or direct that it shall apply with such modification exceptions or recommend. That, sir, is briefly description and effect of this article. I hope the House will carry it.